Hi all, welcome back to a new episode of the weekly political science and the governance issues with regard to UPSC mains GS paper 2. So I have been releasing the videos of the past weeks and I will be doing them in this coming week and also the following week. So let's start off with the weekly polity and governance current affairs with regard to April 9th to April 15th. Let's see what are the important things that happened with regard to the legislature, executive, judiciary and any government major policies that have been announced. So let's have a quick review of the issues that really made news last week. So the most important was that we celebrated the 132nd birth anniversary of the father of Indian Constitution and the chairman of the drafting committee, Dr. B.R. Ambedkar, and it was to commemorate this very birth anniversary, a 125 feet tall bronze statue of the father of Indian Constitution was inaugurated in Hyderabad in Telangana. It is located very close to the state secretariat, and let me tell you that this is the tallest statue of Dr. B.R. Ambedkar in the whole of India. We know that B.R. Ambedkar remains one of the tallest leaders and he is the father of Indian Constitution and an inspiration to generations of Indians continuing his struggle for against caste oppression. His undelivered speech, very famous, called as the Annihilation of Caste, which was written in 1936, and the speech was meant to be actually delivered at a meeting of liberal Hindu caste reformers in Lahore, but his invitation was revoked and therefore it could not be spelled out at that event. He later then self-published the speech, which would go on to become his most famous piece of writing, and he actually describes in his speech the uniqueness of the caste system in India and also the problematic features with this. Let me just read out to you. So he says that the caste system is not merely a division of labor, and it is also a division of laborers. Civilized society undoubtedly needs division of labor, but no civilized society is division of labor accompanied by this unnatural division of laborers into watertight compartments. It is a hierarchy in which the divisions of laborers are graded one above the other. So this statement of his can be a very important mains question and ask you to explain. So you have to write about the caste oppression and what B.R. Ambedkar really spoke about. He is popularly known as Baba Sahib and the chairman of the drafting committee, and he was a champion of the Dalit and the minority rights in India. He was an economist, a social reformer, and also he served as the first law minister of independent India. He belonged to a very poor Mahar caste from Mau district of Madhya Pradesh, and let me tell you, he was the first untouchable to enter into the Elphinstone College that was affiliated to the University of Bombay. He published his book called as The Annihilation of Caste in 1936, in which he spoke about the caste system and also the Hindu Orthodox religious leaders. He formed the Independent Labour Party in the same year and contested the Bombay elections to the Central Legislative Assembly in 1937. He opposed the special status being given to Jammu and Kashmir under Article 370 and also supported the Uniform Civil Code. In 1956, he went on to get converted to Buddhism. Along with him, 5 lakh Dalit followers followed Dr. B.R. Ambedkar, and he was posthumously awarded the Bharat Ratna, that is the India's highest civilian honor, in 1990. So this is about our very great leader and the father of the Indian Constitution. Now the second most important thing is with regard to judiciary, and it deals with the mercy petitions. Now time and again we have heard and seen how the capital punishments have been delayed, and this has led to inhuman treatment of the convicts as well. So the Supreme Court recently has asked the states and authorities concerned to decide on the mercy petition and the pleas of the convicts at the earliest, because it gives them an advantage. This is what the Supreme Court said. So we know that under Article 72 and 161 of the Constitution, the President and the Governor have pardoning powers to decide on mercy petitions. Now, the Supreme Court said that the convicts are actually taking advantage of the inordinate delay in the disposal of mercy petitions. So, this is one side of the argument regarding the delay of the mercy petition. And Supreme Court highlighted that even after the final verdict of the court, the delay in disposal of the petitions would actually frustrate the death sentence. And let me tell you that delay in disposal of the pardoning petitions or the pleas before the president and the governor is one of the ground to commute a death sentence into a life imprisonment, and this has been done many a times. Now, the Supreme Court said that the pleas of these mercy petitions should be decided at the earliest, so that the accused knows his fate and also the victim gets its own justice. The observation of the Supreme Court came when a Maharashtra government challenged the Bombay High Court when the High Court commuted the death sentence of two women on the ground that the pleas took a very long time to be disposed. Now, the Maharashtra governor kept postponing and pending the pleas for almost 7 years and 10 months, which is a very long period of time. And also the Supreme Court said the delay in the disposal of the plea can be a ground to commute the death sentence to life imprisonment. Now, the apex court, while saying this, relied on its own very judgment which it gave in the Jagdish versus the state of Madhya Pradesh in 2020, where it said that it had commuted the death sentence of a person to life imprisonment, considering that there was a 5-year delay in deciding of the mercy petition. This is one of the reasons why the mercy petition should be disposed of at the earliest. Coming to the next important news is about the internal security system, and we have something called as the eProsecution portal. Now, what is this portal and what is the news about? Now, the Ministry of Home Affairs at the center has added a new feature to this eProsecution portal that will fix the accountability of the government to lawyers, and the system will send the alerts to the senior officers whenever a public prosecutor seeks a stay in a criminal case more than twice. Now, this eProsecution portal is a part of a larger interoperable criminal justice system. So it is managed by the Government of India under the Digital India mission, and the portal facilitates communication between the police department and the prosecution directorate, which is a part of the interoperable criminal justice system, or the ICJS. Now, it links and enables seamless transfer of data and information among the different pillars of criminal justice system, like the courts, the judiciary, the courts, the jails, the police, the forensic science laboratories, from just one single platform. The module has been implemented almost 751 prosecution districts and enables seamless transfer of data among the courts, the police, the jail, the forensic laboratories. Now, the main pillars of this interoperable criminal justice system include your e-police, your e-courts, e-jails, e-forensics, and e-prosecution. So, e-prosecution is one of the features of the ICJS, and it plays a very important part in the internal security. Security is an important part of the UPSC GS Mains Paper 3 system, where we have two, internal and external security, and the police taking care of the internal security system. And this was developed independently from the crime and criminal tracking network system. Now, this system connects more than 16,000 police stations across the country and has a database of 28.98 crore police records that can be accessed by the law enforcement agencies and the judiciary all over the country. Moving on to another most important news that made headlines this week, and that's about the Muslim quota now. So it is regarding the state of Karnataka, and Supreme Court commenting on the actions of the Karnataka government. Now, the Karnataka government decision to scrap the 4% OBC quota of the Muslim, let me tell you, Karnataka is going for legislative assembly elections, and this action was keeping in mind the legislative assembly elections that are going to happen in the first week of May. So the Karnataka government decision to scrap the 4% of OBC quota for the Muslims is a prima facie shaky and flawed decision. This was said by the Supreme Court. Now, the Supreme Court said this while it was hearing a batch of petitions that have challenged the validity of the March government 27 government order, which removed the Muslim from the 4% OBC or scrapped them from the 4% OBC reservation. So what happened next? Now, this 4% OBC reservation was divided among the Veerashaiva Lingayats and the Vokaligas, which form a very, very important part of the electorate in the state of Karnataka. So this 4% was taken from the Muslims, that was given to them from very long period of time and transferred to these communities. The state showed haste. This was what the Supreme Court said in issuing the government order based on the interim report, when the final and just on the interim report, when the final report of a cabinet subcommittee was still pending, and it termed the Muslim Muslims are a socially and educationally backward class and were given reservations for almost 3 decades, and all of a sudden this reservation was being removed. So the Supreme Court in turn criticized the Karnataka government for its haste act without waiting for a final report. Now March 27, the Karnataka government made a change which is widely seen as a move at pleasing two dominant backward classes of the state ahead of the May 10th elections, that is the Veerashaiva Lingayats and the Vokkaligas. Now there is a class of persons who benefit, whose benefits are taken away at a stroke, and then there is another class of persons whose benefits are given just at a stroke of a pen, and that too not waiting for the final report but just on an interim report. Now ahead of the crucial Karnataka Assembly elections, the Karnataka government removed the Muslims from the 2B backward category classes, under which the community was given 4% reservation, and pooling them under the EWS category by the March 27 government order. As a result, the reservation for the Vokkaligas and other caste in the 2C category went up from 4% to 6%, while the reservation for Lingayats and other castes went up from 5% to 7%. And the 2D category, that is for the backward classes, Christians and Jains that are classified, even their reservation went up under the 2D category. So this was criticized by the Supreme Court, and now the government is looking into the matter. The next most important news is regarding the right to privacy and also protecting yours and mine data, which is always stored on so many social media platforms and also e-commerce sites as well, and also the apps of a telephone. Now the government told the Supreme Court recently that it's going to come up with a new data protection bill that will be introduced in the monsoon session of the Parliament that will begin in the month of July 2023. Now this was said by the Supreme Court while it was hearing a petition related to WhatsApp 2021 privacy policy, and if it violates the user's rights to privacy under Article 21. Now the development comes after the Apex Court directed the WhatsApp in February this year to publicize its undertaking that was submitted to the centre, that it will not limit or stop the functionality for the users who do not agree with its new update or its new policy, but will continue to just remind them of the changes or the update and not stop offering the services to the users. The Supreme Court was hearing a plea by two students who challenged the contract entered between WhatsApp and parent organization Facebook, where it provides WhatsApp provides Facebook access to all the calls, photographs, texts, videos, documents shared by the users, saying it is a violation of the privacy and also the right to free speech. So in brief, just let me tell you what actually the data protection bill seeks to. Now let me tell you that we do not have any law which data protection law which protects the data of which is stored on apps or social media platforms or your sites, e-commerce sites, etc. We still we rely on the IT rules of 2011 based on the Information Technology Act of 2000. So this new data protection bill will be a game changer with regard to data protection, especially of the citizen of the country, and protect the right to privacy. Now the Ministry of Electronics and Information Technology has prepared a draft bill titled as the Digital Personal Data Protection Bill 2022, and it's invited feedback from the public as a part of its public consultation exercise. Now the bill sets out rights and duties of both the digital Nagrik, that is you and me, the citizen, and the obligation of the digital fiduciary, that is the person or the app or the company or the e-commerce site that actually collects the data. As a part of the compliance framework, it envisages that the setting up of a Digital Protection Board of India to identify and determine the compliance with regard to provisions of the bill and impose penalty if it finds that there is non-compliance of the provisions of the bill, and perform any other functions which are given to it by the centre government that is provided for in the law. So this is the answer given by the centre in an affidavit to the Supreme Court while it was hearing a batch of petitions with regard to right to privacy of the users on WhatsApp linked to Facebook and sharing of data, and how the government said that it's going to come up with a data protection bill which is pending. And let me tell you, many of the countries are protecting the data of the citizen and also where it is being stored also. The next most important is now that we know that the Supreme Court has set up a constitutional bench on same-sex marriage, and there are arguments now that have started on the constitution bench that is headed by our Chief Justice of India, D.Y. Chandrachud, and the Supreme Court is deciding on a plea seeking validation of the same-sex marriage. And let me tell you that it had decriminalized Section 377 and the Supreme Court asked the lawyers to advance the arguments not on the basis of any religious law that govern marriage as an institution, but on the Special Marriage Act. Now, there is a 5-judge bench that has been constituted by the Supreme Court of Chief Justice of India, D.Y. Chandrachud, who is looking into the arguments with regard to the same-sex marriage legalization in India, which is yet not so. So the other judges on the bench are Justice S.K. Kaul, S.R. Bhatt, Hema Kohli and P.S. Narasimhan. Now, the 5-judge bench said that the pleas are very complex and said that the notion of man and woman as referred into the Special Marriage Act is not absolutely based on genitals. This is what the Supreme Court said. In a way, the Supreme Court some way or the other is looking at the issue from the rights perspective, while the government is looking at the issue from the societal perspective. And the government has clearly said that it is only the legislature that has the right to legislate or bring a law with regard to legalization of same-sex marriage, and it is not in the domain of the judiciary. The judiciary should only look at the issue from the rights perspective, where the rights are violated with regard to present laws, etc. And on being pointed about the difficulties and ramifications with regard to the religious laws, marriages in India are based on various religious laws. So we have Hindu Marriage Act, Christian Marriage Act, Parsi Marriage Act, Sikh Marriage Act, Muslim Marriage Act, etc. So it said that ramifications for Hindu Marriage Act and personal laws of the various religious groups were to hold they will not be considered, and instead the Special Marriage Act will be considered by the Supreme Court. Now, let me tell you that the Special Marriage Act of 1954 is a law that provides for legal framework of the marriage of people belonging to different religions or caste or intercaste marriages, and it governs civil marriages where the state sanctions marriage rather than the religion. So this is what. So the center is totally against it. Religious bodies are totally against the same-sex marriage. There are some psychologists and also the LGBTQ community that say that they want rights, equal rights with regard to legalizing of same-sex marriage, so that they can overcome the social stigma and also enjoy rights with regard to inheritance, property and also marriage, and also gain the respect in the society which they need. So there are two arguments with regard to same-sex marriage. And now the Constitution bench, also let me tell you, this is the first time that the arguments of the same-sex marriage in the Supreme Court are being live streamed. The most important news, the next, is regard to the Aam Aadmi Party, a very good news for national parties, especially now the Aam Aadmi Party has become a national party, and some political parties have lost the national party status, and now we have only 6 national parties in India. So Aam Aadmi Party is one party which has gained the national party status, and Trinamool Congress, National Congress Party and Communist Party of India have lost the national party status. So the EC decides whether a party should get the national party status or the state party status based on certain criteria which is included in the Election Symbols Reservations Allotment Order 1968. There are certain benefits that a party gets if it is a national party, and there are certain benefits that a state gets if it is a state party. So the EC decision was based on the review of the party's polls performance in the 2014 and 2019 Lok Sabha and 21 state assembly polls that in 2014. So the status of a national party ensures that the party's symbol is reserved for its candidates across all the country, and it also gets land for the office in the national capital. So this is one major advantage for a national party. Now, the Supreme Court took the decision based on the Election Symbols Reservation and Allotment Order 1968, as I told you, which stipulates and gives the criteria for recognition of a party as a national party or a state party. The EC order said that the Aam Aadmi Party had fulfilled the requirement of being a national party of being a state party in 4 or more states, and therefore it goes on to qualify as a national party. Now, according to paragraph 6C of the order amended in 2014, a party will continue to be a national or a state party if it fulfills the criteria laid down in paragraph 6A and 6B in the next election after one in which it got recognized. So that is 2019. So paragraph 6A states that a state party must have at least 6% of the votes that are polled in the last assembly election and at least 2 MLAs or 6% vote share and 1 MP from that state in the last Lok Sabha election, or 3% of the total seats in the assembly, or 3 seats, whichever is more. Similarly, the paragraph 6B states that a national party must get at least 6% of the votes share in 4 or more states in the last Lok Sabha or assembly elections and have at least 4 MPs or at least 2% of the seats in the Lok Sabha, with its candidates having been elected from at least 3 states. So the Aam Aadmi Party, besides Delhi, Goa, Punjab and now Gujarat, has become a state party in these 4 states at the 2022 assembly elections of Gujarat, where it secured 12% of the votes, 12.92% of the votes. Now there are 6 national parties. Let us look what are they. BJP, Congress, Bahujan Samaj Party, CPIM, National People's Party, and also now lately the Aam Aadmi Party. 6 other parties lost their state party status, and they are the People's Democratic Alliance in Manipur, Pattali Makkal Kachi in Puducherry, Rashtriya Lok Dal in Uttar Pradesh, Bharatiya Rashtriya Samiti in Andhra Pradesh, the Revolutionary Socialist Party in West Bengal, and the Mizoram People's Conference in Mizoram. The next most important is with regard to the Telangana government clearing 3 bills just before the Supreme Court now was going to decide, was going to hear the pending pleas. And so the Telangana governor Tamilisai Soundararajan has given assent to 3 bills returned to the state government and sent 2 others for the presidential assent. Now let me tell you that the president and the governor has legislative powers in which they can either give their assent, withhold their assent, or send back a bill for reconsideration, while the governor has an added power of sending a bill for reconsideration of the president. The petition was filed by the Telangana government after it could not get the assent from the bills waiting for a long period of time for 7 months, and then it approached the Supreme Court under Article 32 and said forced to seek the top court's intervention due to frequent constitutional impasse that was created on account of refusal of the governor to act on the bills that were pending since September 2022. So almost 7 months. Now a division bench of the Supreme Court headed by Chief Justice of India deferred the case by 2 weeks for further hearing. And further, the governor then reserved 2 bills for consideration of the president, and they are the University of Forestry Telangana Bill. So this will be the first University of Forestry in India, and the Telangana University's Common Recruitment Board Bill that were given placed for reconsideration of the president. The governor withheld 3 other bills, that is with regard to the Telangana State Private Universities Establishment, Telangana Municipal Laws Bill 2022 and the Telangana Public Employment Bill. Earlier, the Chief Secretary Chanta Kumari in a petition highlighted under Article 163 of the Constitution, as per which the governor is required to exercise his or her function in the aid and advice only of the Council of Ministers. And so said that even if she is withholding the bill, she has to inform the House about it. Specifically with regard to the governor's power in dealing with the bills, the state government pointed out that pointed to Article 200 of the Constitution and said that the governor may give the assent, withhold the assent, in which case the bill must be returned to the state legislature. This was what the state government has said. And if the bill is so returned, then the House are required to reconsider the bill, which we all know is according to the Constitution. And after reconsideration, if it is sent back, then the governor can either give the assent or then also withhold the assent and even send it back for reconsideration of the president. However, this has to be informed to the state legislature at the same time. Now, with regard to the governor's bills, again, because of the pending issue, Tamil Nadu government has now passed a resolution saying that the centre should come up with a time-bound period within which the governor should inform whether they give the assent, withhold the assent, or are sending it for reconsideration of the president, rather than keeping the bill lying for a long period of time with them. And so asked the centre to fix a time frame within which the governors approve the bill adopted by the state assemblies. So the governor was criticised by the Dravidra Munnetra Kazhagam party, which is ruling there, for sitting on 20 bills almost since 2021. So this is another state which is having a problem with regard to pending of the bills. Article 200 deals with the governor giving the assent, withholding assent, or sending back the bill for reconsideration, and Article 201 deals with what happens when the bill is sent for the reservation of the president with regard to state legislation. And the next most important news is with regard to Centre. The Supreme Court has asked the Centre now to frame a policy on menstrual hygiene. And this was after a plea was filed by Congress leader Jaya Thakur, who said that the Centre should provide free sanitary pads and napkins to girls studying within 6 to 12 years in the government schools across the country, keeping in mind menstrual hygiene. So in a bid to improve the menstrual hygiene in the schools across the country, the Supreme Court now has asked the Centre to prepare a standard operating procedure and also formulate a national model to be adopted by all the states and the union territories for managing menstrual hygiene for girls studying in the schools. The Supreme Court termed the issue of immense importance and very important regarding to health, and said that the Centre should engage with all the stakeholders for the implementation of a uniform national policy for management of menstrual hygiene in the schools, including the government and the government aided schools. So the Chief Justice of India directed the Health Secretary to come up to meet all the nodal officers in the states and the UTs and collect the relevant data with regard to what policy they are now following in the state, and come up with standard operating procedures that can be followed uniformly across all the states and the union territories. The most important next issue with regard to is regarding the minority status. Now there are certain communities that are defined as minorities in the country, but there are certain states and union territories where the majority community is minority there, and now this is posing a problem to actually who constitute the minority. And so there have been a clutch of petitions in the Supreme Court questioning the minority status being given by the Centre under the National Commissions of Minorities Act 1992 to Christians, Sikhs, Muslim, Buddhists, Parsis, Jains, when Hindus themselves are actually minority in several states and union territories. The petition says that Hindus are a minority in Ladakh, where they just constitute 1%. In Mizoram, they constitute just 2.75%. In Lakshadweep, they constitute just 2.77%. In Jammu and Kashmir, they constitute just 4%. In Nagaland, they constitute just 8%. In Meghalaya, they constitute only 11%. In Arunachal Pradesh, they constitute 29%. In Punjab, 38%. And in Manipur, 41%. And the petitions even challenge the validity of two laws, that's the National Commission for Minorities Act 1992 and the National Commission for Minorities Education Institutions Act 2004 for not recognizing minorities based on the population. Now let me tell you that it was in 2002 that a TMA Pi Foundation case that the Supreme Court laid down that for the purpose of Article 30, which recognizes the rights of the minorities to establish and administer educational institutions, religious and linguistic minorities shall have to be identified at the state level. This was what the judgment said in 2002. And the Constitution refers to minorities in Articles 29 and 30, but actually does not define the term anywhere. Neither does the National Commission for Minorities Act 1990 do so, under which the Centre now notifies the minorities in India. The petitions have been challenging the National Commission for Minorities Act, which gives the Centre the power to notify the minorities, and asked how the Centre can do so without a clear definition of actually who constitutes the minority. One of the petition contends that even after the TMA Pi Foundation judgment, the Centre had notified these 6 communities and minorities, and this had become good and valid, and so the Hindus, who are the minority in many states and union territories, do not constitute the minorities there while they are qualified to do so. The Supreme Court now asks the Centre and the states to respond to this petition. The Centre on one hand says that minorities come under concurrent list, and therefore it is a state that should identify the minorities. Few states, Karnataka, Gujarat and Madhya Pradesh, put the onus back on the Centre. They say they are good with the Centre identifying the minorities, and so now the Centre has started a discussion and consultation with the states and asked the Supreme Court certain time to come out with a decision with regard to this. Let me tell you, there are 2 articles now, Article 29 and 30, which deal with the minority rights. So Article 29 protects the interests of the minorities based on distinct culture, language, etc., and Article 30 protects the rights of the minorities with regard to establishment and administering of educational institutes. So these are the 2 rights with regard to minorities, and now we should see whether minorities are based on population and whether the Hindus will qualify for the minority status in the states and the union territories which I've just spoke about. So the government now has launched a scheme for animal pandemic. So let me tell you, according to the census recently, India has a whopping of 153, according to the recent 20th livestock census, we have a whopping 536.76 million of livestock population in the country. And to enhance India's preparedness in response to potential animal pandemics, especially with regard to zoonotic diseases that pose a threat to both animal and human health, now the center has launched a program called as Animal Pandemic Preparedness Initiative. And also the World Bank funded animal health system support for One Health in 5 states. So this initiative will improve the veterinary services, infrastructure, disease surveillance capabilities, early detection, response, vaccine development, research development with regard to animal pandemics in the country. The livestock sector plays a very important role not only in agriculture but also from the point of view of food security in the country. Now, the Big Cat Alliance was launched at the event of the project 50 years of Project Tiger to protect almost 6 big cats with regard to the extension and conservation. And also Prime Minister Narendra Modi inaugurated the International Big Cat Conference in Mysuru, where he said that presently in 2022 India has the largest number of tigers in the world, that is 3,167. Now, Project Tiger was started in 1973 on protecting the habitat of the tigers and also saving the animal and increasing their numbers. Now, from just 9 reserves covering 18,000 square kilometers in 1973, India now has 53 reserves covering 75,796, close to 7,800 square kilometers, which constitute 2.3% land area of India. Now, there are 5 major tiger landscapes: Shivalik Gangetic Plains, the Central India Eastern Ghats, Western Ghats, Northeastern Hills, Brahmaputra floodplains and the Sundarbans. Let me tell you, there have been a reduction in the tigers in Western Ghats. And every 4 years, a report called as the Status of the Tigers is published by the National Tiger Conservation Authority, laying out the information. However, this is not the status of the tiger information, and this was based on the data given by the Ministry of Environment, Forest and Climate Change to the Prime Minister regarding 2022 data, but it's official. So we have 3,167 tigers and 53 tiger reserves. The next big news is with regard to the doctors stopping that strike with regard to Right to Health Bill, which proposes a right to emergency treatment and care. There was a lot of protest regarding this bill. So the doctors say that the bill actually puts the onus of providing health care to the poor on them, and the experts say the legislation ensures health is to be seen as a right. Now, the Rajasthan government and the doctors protest over the Right to Health Bill reached a consensus now. So the doctors have demanded that the private hospitals that did not take any benefit from the government in the form of subsidy or land should be outside the ambit of the Right to Health Bill. The Indian Medical Association, the country's largest physician association, has announced its support to the Rajasthan doctors. Now, medical services were crippled in the state after the government, doctors and faculty went on strike against the bill. Emergency services were exempted from the strike. However, the protests claim that the bill doesn't help the patient much but penalizes the doctors and hospital because it does not define emergency services, and also provides that anyone, when they come for an emergency service to either public or private hospitals, the treatment has to be provided to them at any cost. The bill included that there would be a prepayment, but there was no details of what constitutes emergency services, how the payment will be made, and what hospitals come under the bill. Now, after this, the government has again reconstructed the bill, and some emergency services have been defined, and also some hospitals have been out of the ambit of the bill. The Act does not mention that the government will reimburse the hospitals, does mention that the government will reimburse, but the protesters say that there was no clarity on how the funds will actually come and what actually constitutes emergency services. Now, let me tell you, Delhi has a similar scheme where all the hospitals are reimbursed for emergency treatment if they provide for a road accident or fires or acid attacks within the territory of Delhi. There is also a Supreme Court judgment which says in 1996 that it makes it mandatory for all the medical practitioners to provide emergency care without worrying about the payment. So this was one step that was taken by the Supreme Court which said so. But however, emergency treatment needs to be defined properly so that the particular services can be availed at the right time to the right people, and that too ensuring that the money comes to the people who provide these services. So this was all about your weekly current affairs with regard to polity and governance, and I hope they were really helpful to you. I shall see you in my next post. Until then, very happy learning.